our first speaker, Dr. Anna Adamska-Galant. She is going to share with us some remarks on regaining justice for Ukraine, national and international instruments. That's the topic. Dr. Anna Adamska-Galant is the head of judiciary component of the EU Justice, Prawo Justice Ukraine. She's also attorney in law, expert in criminal law, international humanitarian law and human rights, and the rule of law, also former judge. Since we have 20 minutes of delay, I immediately give the floor to Dr. Adamska-Galant. Please.
Thank you very much. Thank you very much for introduction, and thank you very much for inviting me to join this conference. I will try to be as short as possible. I only want to add that I also used to work as a judge in Kosovo, in the Balkan, where I was dealing with war crime cases in a hybrid court and hybrid model of international jurisdiction. Therefore, I will share more like a practical view, more practical perspective to this, what we observe in Ukraine. And especially that this first panel was very informative, was very scientific also. So I will even skip some points that I wanted to make. And of course, when we talk about regaining justice for Ukraine, the biggest bargain and the biggest burden on delivering justice is on Ukrainian courts. These are national courts, national prosecution, national investigators who need to deal with the vast majority of cases, while any kind of international instruments, they can be involved only complementary. And actually, in case of the International Criminal Court, it clearly results from the statute of its statute, which says that only the most severe violations of international law shall be dealt by the international court. So any international mechanism shall serve as complementary, while the main task on delivering justice is on Ukrainian side. I have indicated here some examples of international law or international acts that are relevant in case when working on war crime cases. As you see, some of them are not implemented in Ukraine as Rome Statute of the International Criminal Court. But I agree here with this, what was raised during the previous discussion, especially by Mikhailo, that we cannot ignore the Rome Statute because it helps to understand it helps to understand better what the international humanitarian law is and what are the international crimes. There was also raised the question of need of harmonization with international standards. And from the perspective of Ukraine, harmonization with international standards is extremely important. This is extremely important to show that the Ukraine is a democratic rule of law state, which respects the fair trial. When the standards are harmonized with these accepted internationally, it is much easier to promote admissibility of evidence. We know that the majority of evidence is being gathered by Ukrainian investigators, prosecution, with involvement of Ukrainian courts. So this is very important that these evidence are collected in a way that is harmonized with international standards. It also has an impact on effective international legal assistance. Ukraine will have to ask for legal assistance. Also, other countries which deal with war crime cases committed in Ukraine, they have to use assistance from Ukrainian side. For the future, it will be also important in the context of recognition of judgments that are being issued by Ukrainian courts. And this last but not least, even I think it should be higher on my list, this use of jurisprudence. As we know, international courts, international tribunals for years have developed a set of principles, a set of tools to interpret, to evaluate specific events in the context of the armed conflict. And they are extremely helpful for you. I believe that they are extremely helpful for Ukrainian judges, Ukrainian prosecutors to deal with this huge challenge that they are facing now. And even, you know, in many occasions when we conduct like trainings or workshops or seminars with Ukrainian judges and prosecutors on how to deal with war crime cases, we always refer to the jurisprudence of international courts, also to show the nuances, because it's not, you know, the international humanitarian law, war crime case is not obvious. There are so many nuances that needs to be identified. And I'm not going to speak a lot about this because it has been already mentioned that according to the Ukrainian constitution, international treaties that are in force and agreed to be binding, they become part of Ukrainian national legislation, but they need to be properly implemented. And this was already raised during the first panel in the context of for example, the Rome Statute. Ukraine has not ratified the Rome Statute yet, which creates, I think, challenges for Ukrainian judges, Ukrainian prosecutors when they deal with the war crime cases, because the Rome Statute contains the most comprehensive most comprehensive list of international crimes. And I just want to remind here that Ukraine made a commitment to implement the Rome Statute of the International Criminal Court when Ukraine signed association agreement between the European Union and its member states in 2014. So this is like the obligation that is still pending on the country. It had been already mentioned by my honored predecessors, speakers today, who have been talking about the draft law that has been already adopted by the Verkhovna Rada to amend certain legislative acts of Ukraine concerning the implementation of international and humanitarian law norms. And this is a very comprehensive document which allows for implementation in the legal order of Ukraine all these necessary norms that would allow for effective investigation and adjudication of violation of international humanitarian law. Unfortunately, for the last 2 years, this draft is awaiting the signature of the president. When it comes to shortcomings in the Ukrainian criminal law, my colleagues already have mentioned them. So just very shortly to kind of sum up. So this is like lack of comprehensive incorporation of the international humanitarian law. There are not sufficiently adequate definitions. There's also like definition of crimes against humanity. There is also the question of command responsibility, which is not fully clear under the Ukrainian law. Of course, judges can interpret the law. They can interpret the law. They can try to kind of solve the problem. Actually, they need to solve the problem. But as this is the criminal law should be as strict and as precise as possible. What is also interesting, and I would like to refer your attention to the referral of Ukraine to or declaration of Ukraine to recognize jurisdiction of the International Criminal Court. As you know, Ukraine filed such declaration twice in 2014 and in 2015. And these declarations have raised some doubts because these declarations, they are somehow limited because they say about serious violations of international criminal law, which have committed only by Russian side against Ukraine. And as you can see, when the prosecutor of the ICC, Mr. Khan, on the 1st March 22, announced that he's going to investigate, or that the prosecution office is going to investigate the situation in Ukraine, he was clear that this investigation will encompass any new alleged crimes falling in the jurisdiction of my office, that's a quote, that are committed by any party to the conflict on the territory of Ukraine. So the ICC prosecution is clear. They are investigating both not only crimes that have been allegedly committed by Russians against Ukraine. As I have mentioned at the very beginning, the main burden of dealing with war crime cases, of investigating of war crime cases, is on Ukrainian side. And there is no state, we can speculate, but there is no state in the world that would be able to fully handle with all war crimes allegedly committed during the ongoing conflict. And when we talk about the challenges that the Ukrainian judiciary is facing, so this is the question of expertise. And I really like the presentation that was made by Professor Konstantin Zador, where he mentioned these weaknesses in understanding of the international humanitarian law. And this is something that needs to be improved. It requires a lot of working, but as I underlined, no legal system would be ready to deal with such a number of cases. So this time is needed. And what I can say is that we observe that our Ukrainian colleagues are really developing, are really learning, and they are gaining experience. And this is very important because they have more experience, more knowledge, and they put more and more questions, which shows that they really understand the point. What is also the issue? This is the manpower. When we talk about the manpower, perhaps you are aware of this, that the judicial system of Ukraine is suffering from the big number of vacant positions in the system, like about 30% of judicial vacant position in the system, which means that this is like this amount of cases that are being brought in the system, war crime cases. It is additional burden on judges, on prosecutors, on investigators. It is also a question of infrastructure that is being demolished by Russians continuously. This is also a question of time. And there is like expectation, especially from the public, that the justice will be delivered fast. But experience from other conflicts, from other wars where the perpetrators were put on trial, shows that sometimes there are years needed. It's sufficient to speak about Bosnia and Herzegovina. The war ended more than 30 years ago, and there are still trials going on in Bosnia and Herzegovina, which are connected with war crimes committed during the fall of Yugoslavia. And of course, a very important issue that Ukrainian courts need to deal with, despite this is the war that is going on. There are the security questions. The courts are being often under fire. And what is maybe for us surprising, it often happens that judges in Ukraine, they continue sitting and hearing cases despite despite alarms. In context of the security, we can also talk about the security of the defendants, the security of witnesses, which is very important. In the context of evidence, we must be aware, or we must remember that the war in Ukraine is the most documented war ever. This war is going on our eyes. The scale of this war is huge. And also it is the point that actually everybody now feels like obliged to deliver evidence on this war. Everybody has an iPhone or phone, can make a video, can make a photo, and many people want to share. So objectively, the prosecution office in Ukraine is overloaded, or is receiving a huge number of evidence. Another very important challenge related to collecting the evidence in Ukraine is limited access to sites of alleged crimes. There are such places, especially these which are under still occupation of Russia, like Mariupol, where it's not possible for any investigator to come. It is not possible to collect evidence, and actually it's not possible to verify, especially in Mariupol, what had happened there. And of course, this is a huge amount of witness. There are actually, we can say that almost every Ukrainian citizen is somehow affected by the war. Many of them have suffered tremendous suffering. They go through trauma. They can be also under pressure to testify in a specific way. In the context of, for example, sexual violence, which is often committed as an element of a war crime, there is a risk of stigmatization. And we know that the scale of this sexual violence committed as war crime is very huge. So in general, the system, the judicial system, or the system of justice in a wider sense, should ensure this kind of support for witnesses, because the witnesses, they bring information. They are the source of information, often crucial, which needs to be analyzed in the context of the proceedings. I would also indicate a very important factor which must be taken into account. This is, I called it here at my presentation a human factor, because the war is going on, and actually we can say that all judges or lawyers in Ukraine are somehow affected by the war. Many of judges have been displaced. Many of judges lost their relatives, their loved ones, not talking about property. So in this sense, the conflict is the war. The war is going on. Actually, every day there are alarms, there are bomb shelling, people are being killed. So this is extremely difficult for judges in Ukraine to stay fully impartial and not being biased. And this is a challenge that Ukraine needs to deal with, because I spoke about this declaration to the ICC on purpose, to indicate that we must be aware that war crimes, when there is the conflict, war crimes are committed on both sides. Of course, the scale of the war crimes on one side is not comparable to the scale on the other side, on the Russian side. But it may happen that also there should be a Ukrainian defendant put on trial on one side, and that the Russian defendant who is standing before the Ukrainian court, or they have right to a fair trial. They have right to presumption of innocence. They have right to be defended. And we know about this, that it happened that, for example, not only there's a pressure on judges, it's often a public pressure, public expectation for very severe punishment, for very fast punishment. And also we know from lawyers working on war crime cases who are appointed ex officio to defend Russian defendants, that they face kind of ostracism or kind of critics even from the legal community, who kind of blame them for performing their task to defend. So I want to underline once again that this is very important for Ukraine, to show that its judicial system is capable to ensure the fair trial to each defendant, no matter if it's Russian or if he or she is Russian or he or she is Ukrainian. Another reason that is always connected with the ongoing conflict, with the ongoing war, this is the question of justice, of the victors. So we are waiting for the victory of Ukraine, of course, and it's important that the justice will be delivered, but not only for the victors. So this is all from my side. Thank you very much for your attention. I'm ready to answer any questions and comments after the panel is finished. Thank you.
Thank you very much. Thank you, Dr. Adamska, especially for this third part concerning human factor. As a judge, I'm particularly grateful for words concerning judicial independence and obligation to offer everybody fair trial. And now we move to the second second speech, second contribution. I would like to introduce Ms. Zera Kozlieva. She is a senior legal advisor in Proof House. She has also 9 years of experience in the Prosecution Office of Ukraine, most of them investigating war crimes during the entire armed conflict in Ukraine. In particular, she worked in the Office of the Prosecutor of the Autonomous Republic of Crimea, relocated to Kiev, as well as in War Crime Department of the Prosecution General Office of Ukraine. Ms. Zera Kozlieva will speak about prosecuting crimes committed in Ukraine by Ukrainian legal system, and she will focus on case study and current trials. Please take the floor.
Ще раз добрий день, шановні колеги. Я дякую.
Hello again, dear colleagues. Thank you so much for having me here. A little bit clarification in terms of my experience, my work experience in Crimea. It was moved to Kiev, this prosecutor's office. And listening to previous speakers, I a little bit shifted my focus because it very much resonates with me what was mentioned by Konstantin Hodzadoy and by Anna in terms of right to fair trial and unbiased and impartial justice. It's the issue of transitional justice. It's very important to show that it's not the court of the winners over the losers, that it's ensuring the right to a fair trial. Sometimes we do face these challenges. In 2014, when for the first time there was even within the office of the prosecutor general, there was a department on the occupied Crimea. And there were those challenges that right now were mentioned, in particular, impossibility to access the territories where the crimes were committed. There was no judicial experience or no investigative experience. The question of how to qualify those crimes, how to take it into account, given that we speak of international criminal law and national criminal law. The issue is that the prosecutors and the investigators do not write the laws. They apply the legislation of Ukraine that is in place. Indeed, international law is part of national legislation of Ukraine, but only within the framework of the ratified international treaties. And it was mentioned that we recognized the recognition of the International Criminal Court, but we did not ratify the Rome Statute. That's why. And that's how we allowed, as back as in 2015, to the International Criminal Court to hold its own investigations under the Rome Statute, but the application of the Rome Statute by the national investigative bodies indeed wasn't important. We only used it within the part of how we can interpret and how we can apply the norms within the Geneva Conventions and other international human rights treaties. It was back in 2014. Now we can cover the statistics of the crimes that are war crimes as of today. We a little bit mentioned the statistics based on April, and for now it's almost 87,000 criminal proceedings. Given that, when we mention the national jurisdiction of investigations within the Ukrainian legal order, I have two most important points. First, that we have some sort of architecture and infrastructure of national bodies aimed at such crimes. That is, we cannot say that Ukrainian national system is not ready. It's much more ready than it was, for example, 9 years ago, because we have special war crime department within the office of the prosecutor general. It was created in 2019. Back then it was responsible for committing for crimes committed in the temporarily occupied Crimea in Donbass. After 24th of February 2022, it was very much enlarged in view of the full-scale invasion. But the prosecutors and investigators who were undergoing specific training on international humanitarian law and international criminal law, we had them already. That is, we had institutional capacity. But of course, it's not enough given the scale of the criminal offenses that are committed today. In respect of the challenges, I'd like to mention the issue of legislative gaps, both within the substantive and procedural law. The substantive law I will not be covering very much because the previous speakers gave a lot of attention to that.
Увагу на те, що особливістю міжнародних злочинів є те, що вони не мають строків давності, до них не може
It is a common knowledge that the peculiarity of international crimes consists in the absence of the limitation period. No amnesty can apply to international crimes. However, if we talk about the application of criminal jurisdiction of a national jurisdiction, we still need to keep in mind some requirements of the national legislation. For example, there are terms for pre-trial investigation. So it is quite hard to combine these two aspects of absence of any limitation period on the one hand, and associated requirements regarding the trial investigation and terms and deadlines for the pre-trial investigation on the other hand. Speaking of verdicts issued in absentia, it is another brings about another block of problems. Unfortunately, Ukrainian legislation do not provide for the reconsideration of a case of a case in the event the alleged perpetrator shows up, and there is even a respective judgment of the European Court of Human Rights stating that absence of respective mechanisms in international legislation may constitute a problem in the future. Speaking of Article 438 of the Criminal Code of Ukraine, which falls within the jurisdiction of the state security service of Ukraine. The deeds envisaged in the article may be combined with so-called regular crimes such as homicide, rape, and so on, which are investigated in the normal life by the law enforcement bodies, by the police rather than the security service of Ukraine. There are no guidelines on for the state security service about how to deal with such crimes when committed under martial law. Speaking of crimes against humanity, they are not part of Ukraine's national legislation. We only have three international crimes included in Ukrainian legislation, and even those which are there differ in terms of definition and in terms of scope from the respective provisions of international instruments, including the Rome Statute. At the end, I cannot but mention the establishment of a joint investigative team composed of Ukrainian, Polish, and Lithuanian professionals. Professionals from other jurisdictions also take part in the investigation conducted by the mentioned GIT.
Певний місточок стосовно того, що
in the light of this discussion and the topic of panel 3 about universal jurisdiction brings me to the following point. Not always international experience of existing experience of international prosecution for international crimes may not always be adaptable for the Ukrainian context. So my point is that we need to get inspired by international experience, by countries where universal jurisdiction has already applied, but in the meantime to develop a customized tool. So having professionals from other countries in JITS is something which would contribute to picking up best practices and best solutions from other countries in terms of application of universal jurisdiction, among others. And finally, last but not least, I can see some positive progress in the investigation and prosecution of international crimes committed in the territory of Ukraine. So after the full-scale aggression, there is a trend to consider the war conflict as lasting starting from 2014. This is important from the standpoint of establishment of the context of crimes, because as it has been mentioned today, we need to apply a uniform approach, and we need to avoid situations where there will be discrepancies in the establishment of contextual circumstances in various criminal proceedings. This is it. Thank you very much for your attention.
Thank you very much for your contribution and some important information concerning also joint investigative teams. Now we move to some remarks concerning collection of information of evidence within the framework of Sunflower Foundation, and also coordinator of the project of Sunflowers. Also academic with national and international experience, including experience in trust fund for victims of the International Criminal Court of in The Hague. She's University in Białystok, Andrzej Frycz-Modrzewski, Kraków University, and Łazarski University in Warsaw. Ms. Dr. Ewa Hofmańska will share her views on as I said already, on collecting information of evidence of crimes committed in Ukraine. Please take the floor.
Thank you. Thank you, Kasia. Dear all, I'm very happy that Project Sunflowers is one of the organizers of this very important conference. I'm also pleased with the unexpectedly large attendance at today's event. This proves that the topic of bringing justice to Ukraine is extremely important for the international community. This panel discusses various aspects of complementarity in the context of the jurisdiction of the International Criminal Court, the courts of Ukraine and other states. Dr. Anna Adamska-Galant has just spoken about legal aspects of the issue of complementarity, and therefore I'm not going into these issues. In my speech, I would like to point out some essential practical aspects of this complementarity. Any legal proceeding, and in particular, a criminal proceeding, will only be successful if decisions are based on reliable evidence. The information gathered must serve as an evidence based for all possible accountability mechanism. Obviously, it's a huge challenge to find a key to distribute the task of the different accountability systems and thus close the impunity gap in the most efficient way possible. Decisions must take into account the capacities of the individual systems, but also the ability to provide process which meets standards required by the rule of law. This prism of assessment is built into the Rome Statute system of complementarity. And for this reason, it would not be possible, for example, to conclude that without the guarantee of criminal proceedings before an independent and impartial court, a trial meets the criteria set out in Article 17.2c of the Rome Statute. However, I'm not going to talk more extensively about the criteria for deciding on the prosecution of perpetrators of crimes committed in Ukraine, as Anya Neistat of the Clooney Foundation for Justice will say more about that. Project Sunflowers aims to collect information about evidence of crimes committed in Ukraine and about victims of these crimes. This information will be stored in a secure database in order to then provide access to international and national law enforcement authorities. In time, information from our database
захищені платформи. Інформація буде передаватися відповідним органам, які будуть брати участь в реалізації юрисдикції для притягнення винних до відповідальності, але також і з органами тих держав, які долучатимуться до виплати стягнення репарацій з Російської Федерації за вчинені міжнародні злочини, в тому числі геноциду, злочини проти людяності та воєнні злочини.
Crimes committed in Ukraine. We are not investigators and therefore collect evidence, but only information about evidence. Information we provide to the competent authorities will have to be proceed in such a way that can be used for ongoing investigations. At the same time, it should be kept in mind that the admissibility of evidence can and is shaped differently in the ICC and, for example, in Poland. A key element of post-conflict justice is the reparative element, which is as important and perhaps even more important than the retributive one. For this reason, the Project Sunflowers team emphasizes the collection of information about the damage that has already been suffered as a result of the conflict and the persons harmed. Information on the types and extent of harm suffered, together with information on the persons affected, will allow appropriate reparation programs to be prepared in the future. As I mentioned earlier, the information we collect will be stored in the secure database in order to be able to pass it on to international and national authorities established to prosecute and adjudicate perpetrators of international crimes committed in Ukraine, as well as to authorities that will participate in future reparation proceedings. If a special tribunal for aggression or a hybrid tribunal is established, Foundation Sunflowers will also notify such a tribunal of the database and provide access to it. No other authorities or institutions, not even the foundation itself, will have access to the forms filled out by potential witnesses and victims of this war. In time, that is when we have the information already collected, we will notify the authorities that might be interested in accessing it. I cannot, for obvious reasons, say in detail how this communication will look like. I will only say that a separate application will be prepared for this communication. From the very beginning, as soon as we first thought about the project, we were aware of the need to ensure security, not only in collecting information from potential witnesses and victims of the war in Ukraine, but also in storing it and transferring it to the competent authorities. With this type of project, the biggest challenge is to ensure security, especially when we are talking about the collection of sensitive information, such as personal and contact details, and information with a strong evidentiary potential. The cost of creating the software to securely collect the information and then the software to securely transmit this information to the competent authorities, and the cost of maintaining a secure database are extremely high. And costs are the main cost of the project Sunflowers. Raising money needed for the project to be carried out as intended is currently, according to our assessment, the biggest challenge for the Foundation Sunflowers, which is responsible for the implementation of the project. Even before the foundation was registered, and it was registered nomen omen on 24th of February this year, we launched an online collection via the recognizable crowdfunding platform pomagam.pl under the banner Justice for Victims of the War. Today, Foundation Sunflowers has already a bank account opened where you can make a donation directly. Technically, we are able to collect many thousands of testimonies from survivors of the horrors of this war. I want to emphasize that the scale of crimes committed every day in Ukraine is so huge that no justice system can cope with collecting such an enormous volume of information. The history teaches us that post-war justice has never covered all the criminality and has never brought reparation to all those who suffered harm. Nevertheless, we must do everything possible to ensure that the impunity gap is minimized. And this is what we had in mind when we created Project Sunflowers. The collection of information will be done exclusively online by voluntarily filling in a form that the project team has designed. I want to stress that collecting information at this stage of the conflict is just as important as it was a few months ago, right after the Russian invasion of Ukraine began in February last year. None of us knows how long this war will last, how many more victims it will bring, and what destruction it will cause. Moreover, human memory is fleeting, and the memory of survivors who have experienced the trauma of war can play tricks. Moreover, people who have witnessed the most atrocious crimes, which cannot even be imagined, have the right not to want to talk about their experiences to anyone, even if they have extremely valuable information. Such vulnerable persons may unblog themselves few years after the end of the war, when they have worked through their trauma and feel safe enough to talk about their experiences. This also means that our project is by design long-term one. Surely, our plan was to launch the form as soon as possible. Unfortunately, from a technical point of view, and due to a lack of funding that would have solved immediately many problems, we are launching our application today. And we'll emphasize that everything we have done so far in the project has been based on our pro bono work. And I am very grateful to everyone who has given the time and energy so that today Project Sunflowers is here and can start collecting information. After many months of preparation and testing, I can say today that the application is ready to use. Due to the time frame of my speech and the conference itself, I will talk today about the app very generally and briefly. I would like to right now invite you all to a separate online meeting on the 6th of June at 6 p.m. Central European time, where we will present the application explaining how it works. So to fill the form, you need to go to the project website, which is projectsunflowers.org. Then click the red Share Information button. Here you will first see a request to contact a project volunteer. A volunteer will contact the person and then send them an activation link to open the form. For now, due to cost, the form is available in three language versions: Ukrainian, English, and Polish. Hopefully, as a result of donations, Project Sunflowers will soon be able to make the form available in further language versions. The person providing the information will have as much time to fill in the form as they would like to. Information typed in will be automatically saved as a draft version of the form. This is because we are aware that especially people who are still in Ukraine and who would like to fill in the form may have some problems with access to the internet or electricity in general. As long as the form has not been sent, the draft version will be available for completion. It will be possible to upload videos or photos to the form. All attachments will be forwarded to the competent authorities to be analyzed for the purpose of their proceedings. Probably not all persons who send the form and even upload photos or videos will be called as witnesses by the authority concerned for the ongoing proceedings. Who will be a witness in the procedural sense will certainly be determined by the type and gravity of the information they provide. The personal and contact details of these persons will only be provided to the authority when the authority makes such a request to the foundation. This is because, first, such an authority will be given access to information about the incidents witnessed by the person concerned and or the damage he or she has suffered as a result of the war in Ukraine. If the analysis of this information indicates the need to contact the person who provided it, which may occur if the information provided proves to be relevant in the context of a pending case, then the authority will request the foundation to provide the contact details of the person concerned. When it comes to future reparation proceedings for victims of this war, I also want to make it clear that completing our form in the section on damage suffered as a result of the war doesn't yet mean that reparations will be individually awarded to each person who completes this section of the form. the information on the damage caused by the crimes committed in Ukraine, which Project Sunflowers collects, is intended to help authorities implementing reparation programs for victims of armed conflict in the future, to prepare programs adequate to the scale and type of damage caused. Undoubtedly, the damage information will be provided to us will facilitate the screening process of beneficiaries of future reparation programs, which can only speed up the start of reparation programs. Each person, after submitting the form, will receive a confirmation of the submission. There is no obstacle to the same person filling in our form and submitting exactly or even different information to another project or authority directly. I would even say that all the authorities or projects already involved in collecting information, as well as those who are just about to start collecting it, after all, have the same goal: to bring to justice those responsible for all these atrocities that are taking place in Ukraine. Project Sunflowers team has made every effort to make the project unique. Also, because our database may turn out to be the largest such database in the world. As I said before, we are going to tell you about the details of, for example, logging into the application, submitting the form, deleting draft version, supplementing the forms with additional information, and uploading videos or photos at a separate meeting. It will take place on 6th of June at 6 p.m. Central European Time. Please keep an eye on our social media where we post updates and publish current information about our activities. We will also post a link to the meeting, meeting soon. Thank you very much.
Thank you, Eva, for very, very rich speech concerning Sunflowers project. Now we know in details the scope and goal of the project. Thank you also for invitation to the meeting on 6th of June. Now, because we are still out of time with a short delay, immediately I would like to take the floor to the last speaker of this second panel, Miss Ania, Dr. Ania Neistat. She is a leader in the DOCET project, which is an initiative of the Clooney Foundation for Justice, which focused on accountability for perpetrators of international crimes. She is also the chair of the board at Crisis Action, an international organization working with global civil society to protect civilians from armed conflicts. She holds an LLM degree from Harvard Law School and PhD in law. She has a great experience in fact-finding missions in conflict areas and conflict investigation, conducting investigations in conflict areas around the world. Ms. Ania Neistat will focus on universal jurisdiction and prosecution of crimes committed in Ukraine mapping program. She will provide us with information on that. Dr. Ania Neistat, the floor is yours.
Thank you so much, and thank you, distinguished colleagues. It's a huge honor to be part of this panel and part of this conference. I see a few names of people with whom I did overlap over this last year or before, and some are new, so it's a great pleasure, and I listened to some of the previous panels. The discussions are truly rich. I also know that it's the worst spot to be the last speaker between people and their lunch, because I do hope that the organizers will give people a few minutes to grab a sandwich, so I will be very short. For those who do not know about our organization, the docket, a part of the Clooney Foundation for Justice, focuses on investigations and legal action in cases of international crimes. Ukraine is now one of our projects, but probably the biggest one. I personally have worked in Ukraine since 2014, so my experience dates further back. Since this February, we have a team that focuses on both collection of information in the field, open source analysis, and preparing cases, primarily for universal jurisdiction proceedings in European countries and beyond. We also are obviously in touch and collaboration with the International Criminal Court and their investigation, and the Ukrainian prosecutors and police. So I think there is really a lot of expertise in this virtual room. So I will not go into details that I normally explain about universal jurisdiction and why and how. I would just say probably two words that, or two topics that kind of jumped to me from some of the previous discussions. One is why do we even need these national proceedings when we already have ICC investigation and we have 80,000, probably now more, my figures are a little bit outdated every time I quote them, in Ukraine? And the answer is, for me at least, quite simple. On the very practical level, we know that ICC would ultimately go after a handful of perpetrators, hopefully the top-ranking perpetrators, and Ukrainian prosecutors will, by and large, have their hands full with the immediate perpetrators. It was already mentioned that Ukraine does not have the doctrine of command responsibility per se in its criminal law. I know it's not as straightforward, but I'm simplifying because I know it was already discussed. And at this point, in the absence of this doctrine, it is a very important complementary way to go after mid to high level commanders to pursue cases in jurisdictions where the doctrine of command responsibility exists and other factors are in place for us to be able to proceed with these cases. And of course, that requires close coordination between ourselves, the lawyers, the investigators who represent Ukrainian survivors and witnesses in such cases, and prosecutors on both sides. So Ukrainian prosecutors and the prosecutors in Germany, Poland, and other countries. I will show you in just a few minutes basically I would say the side product of our work on Ukraine, because it was not part of our intended work plan, but came out of the fact that we, from the very beginning in February, started looking into which countries, okay, universal jurisdiction sounds good, but which countries would it actually be realistic to bring cases on behalf of Ukrainian survivors? And we were absolutely certain that somebody has done this mapping before, but it turned out that it has not been done. Yes, there are bits and pieces of that done by other organizations, but some of them are outdated and neither is comprehensive enough. So we wanted to know what happens if we end up with Ukrainian survivors in Senegal or Thailand, or even more likely Russian perpetrators in Dubai or in Turkey. What is possible in all of those countries? So I will show to you in a second the tool and how it works, and I hope you will find it useful. But one thing I wanted to mention before that is there was a lot of discussion about kind of the practical implications of all of this work. You know, as it's been said already, everybody's collecting evidence or collecting information that can be turned into evidence. There are several accountability processes in place, but in reality, would all of that result in trials in absentia? And I think one of the work that we started doing and kind of very closely looking into is the whole issue of arrest warrants issued by national prosecutors elsewhere and turned and processed through Europol and Interpol systems. And I had a very good meetings with Europol, and we're trying to kind of establish a more close relationship with them. And it's very interesting because what I didn't realize is that the Europol system includes much more than just European countries or EU countries per se. It does have representatives sitting in the same building from Turkey, from United Arab Emirates, and now from Ukraine, which is very, very positive because this level of coordination is critically important. And they do have investigative teams, and they actually have, if not, direct enforcement powers, but much more levers than, for example, Interpol. And so we are working with the first practical goal of having arrest warrants issued in France and Germany, hopefully in Poland and elsewhere, so that these cases are out there, the arrest warrants are out there. And while we are not very hopeful that a Russian commander will come visit France or Germany in the near future, they are, at least some of them, much more likely to go to Turkey or to Thailand or elsewhere, Serbia. And my line on that has always been that, is it sure that they will be arrested and extradited and prosecuted? Of course not. It will depend on the political climate. It will depend on many other factors. However, what we can be sure is that if the arrest warrants aren't there, they will happily have their vacation and go home. And that's, from what I understand, was exactly what happened with what's his name, Martinov, the Russian colonel who was in Turkey as the head of relief operation for the earthquake. Well, there was vast amount of information on his potential implication in crimes committed in Ukraine. There was no way that, basically the Turkey would process the extradition request. And I think there would have been much more likelihood of that happening if an international arrest warrant was out there. So I encourage colleagues to keep thinking about this. We don't have all the answers, but that's definitely something that emerged from us thinking about at least the immediate practical implications of this work, and very happy to discuss with everybody offline. But keeping true to my promise to keep it short, I will just share with you a quick glimpse into this project, which is called Justice Beyond Borders. I hope everybody can see the screen, right? Yeah?
Yes, we do.
Okay, great, fantastic. So basically, you can read about the project and about the methodology, but basically what we did, we surveyed 216 jurisdictions. So all of the UN member states, plus some other jurisdictions, and there is an explanation in the methodology as to how we chose additional jurisdictions and why. And, there is a detailed methodology section that describes what we did and what we didn't, and whom we consulted with, and how the information came in there. But ultimately, what you can see here is either world, regional, or country view, which basically shows you how it might work in a particular jurisdiction. We focus so far only on 4 core crimes: genocide, war crimes, crimes against humanity, and the crime of aggression. The next stage of the project will tackle other crimes, including torture, disappearances, human trafficking, and some other international crimes. And there are other again, if you read about the project document, you will see that there are other next steps that could be done, could be undertaken. But the whole idea of this tool is that it's not an academic exercise, although it does have some interesting conclusions in the summary. It's a practical tool. The question is, if we have a survivor who's in country X, is that sufficient grounds for us to bring a case if this person is a refugee, or does this person need to be a residency? Like, what are all sorts of intricacies of passive personality? If we have a perpetrator who we think might be traveling, or whom we want to lure into a particular country, what would be the conditions in that country? How many countries have what is called absolute universal jurisdiction, where there are no conditions applied to that? Not too many, but some of them are quite interesting, including in Eastern Europe. So basically, I encourage you, I will send the link now to the chat, but I encourage you to explore it. If you go to the world view, for example, apologies. So you can scroll the globe and see, oops, it's not scrolling as quickly on Zoom, but you can scroll the globe and you can select whatever you want. You can select regional view. And then again, because it's a tool for practitioners, you basically go on this left side and you select what you're interested in. For example, you're interested in countries that could prosecute all for international crimes. And then you just need to enter certain conditions. Alleged perpetrator is in the country of territory. For example, we say no. Oh, sorry. And then you will see some other conditions. So here, basically, we say that, you know, the country can start a case with no conditions. Command responsibility. The country has criminal law provision that would allow for the investigation of commanders, something that is very relevant is of Ukraine, whether the country has ratified and domesticated Rome Statute. And I know, in case Ukrainian colleagues are looking into Ukraine, we did have a mistake there. I think it's been corrected now, but there weren't many mistakes from the original version, but we did try to correct them immediately, and so on and so forth. So, and then you can have a list of countries, and then, you know, go and see a little bit more what each of these countries can offer. For example, I mean, Germany is always a relatively simple example. So the country has at least one serious international crimes in their legislation, so they have all of them. What are the conditions? Can investigate crimes, war crimes committed beyond their borders, if so, with no conditions, or if any of these conditions are met, and so on and so forth. So for the sake of time, I would encourage you to just play a little bit with that. You'll see it's very, so far, all the feedback that we got was that it was very user friendly and you shouldn't have any problems. And of course, it's kind of version 1. And as I mentioned, there are quite a few things that we would like to add here, including resources for survivors in given countries, because we always say that our work is entirely survivor focused. So this seems like a very legalistic piece of it. But what we always look into is when considering going for a case is whether there are sufficient services such as, you know, protection, social, legal, medical available for witnesses and victims in those countries. There is, as I said, some interesting summary information in the about the project section. If you're interested in some statistics, there are some key facts and analysis, and some discussion about both the opportunities and the challenges that universal jurisdiction presents. For those who are very interested in methodology, there is a detailed methodology section, and the entire data set is actually available. There is a link to the data set that you can play with if you're interested. There are also additional resources, links to detailed reports, to which you can get both from the country section, for example, reports by Ultra International, by some other organizations that have looked in detail. And there we also include some case examples. So I'm going to stop the demonstration here and send you the link. And obviously, if you notice any inaccuracies or would like to see something else added there, there is, I believe, a feedback form there. Please feel free to use it, but please also feel free to share it with your networks. I would say just one last thing in conclusion. I started with very practical answer to why these universal jurisdiction proceedings for crimes committed in Ukraine are so important right now. And I will end with much more, much less practical, almost kind of symbolic meaning of what we're facing right now in the world, and also why universal jurisdiction proceedings are so important from that perspective. I do think that we are in a unique moment, uniquely difficult and tragic moment for Ukraine, but in some ways a uniquely opportune moment for international justice. I do think that over the last couple of decades, many pieces have been put in place, and accountability for Ukraine, for crimes committed on Ukraine, is literally our common way of testing whether some or all of these systems work and how they work in connection to each other. And I do think that if that goes well, it will have enormous significance, not only for Ukraine, not only to survivors of horrendous crimes committed there, but also have very long-term consequences for atrocity crimes committed elsewhere. Thank you very much.
Thank you very much for very interesting information concerning especially practical tools concerning universal jurisdiction. So we received during this panel two practical tools, one concerning procedure, information on evidence, Sunflowers project, and second concerning also very practical tool concerning much substantive criminal law, I mean universal jurisdiction. We have still 14 minutes for discussion. I see on the chart the first question, the old one, the first question put on the chat today morning. It was not answered during the first panel. So if somebody, maybe somebody from panelists of this panel would like to address this issue, maybe I will translate this question. The first question for today concerns scope of the joint investigating teams, scope and aim of this joint investigating team. I remember that Ms. Zera Kozilieva addressed this issue during her speech, but of course, and maybe to address this question. I open the discussion, of course, for everybody. We have still 12 minutes. I don't see any raised. So. Nobody. The last chance. Otherwise, I will close the session. So I would like to draw, Mr. Szepitko has a question, but before giving the floor to you, I would like to draw your attention to very interesting materials sent to us by participants, panelists, and also of the conference on the chat. You have a lot of interesting information. Mr. Szepitko, yes, please.
Я бачу, що приєдналася пані Зера, можливо, вона...
I can see Zera joining back the discussion. She might want to answer the question which was articulated by the moderator. Could you please repeat the question?
Пані Малгозата, можна повторити запитання?
I saw on the chat. I saw on the first when I open the chat, I see the question, the first one, Polish, written in Polish. Now I translate the question. What is the scope and goal of international investigative team? Which countries are now in this team? The question of somebody, I don't know who raised this question, but it's the first one on the panel.
Так, дякую за запитання, дякую, що повторили.
Thank you for the question. Joint investigative team was initially established by Poland and 3 Baltic countries. Later on, it has been joined by representatives of Slovakia and Romania, then the international criminal courts also stepped in. These are parties alongside Ukraine. What does it mean having this joint investigative team? It means that in each respective countries there are separate investigations upon the same factual background. It doesn't mean that the qualifications of this within these investigations are the same in all countries.
Грають дотичну таку, скажімо, роль для того, щоб Євроюст, в який входять всі країни.
The GIT also includes representatives of Eurojust. In a nutshell, within the national investigations, each country conducts investigative actions. Eurojust provides overall organizational support so that the efforts of participants do not overlap. Hopefully, I have given the answer to the question.
Thank you very much. It was not my question, but I saw it on the list. Mr. Szepitka would like to take the floor, please.
Дякую за можливість. У мене запитання до Ані Нейстад.
Thank you. I have a question to Madam Anya Neistat regarding mapping of crimes. It so happened that I'm interested not only in criminal law but also in forensics. So my question is the following: how does one do some such mapping? So, if I'm not mistaken, digital forensics should apply here, or seen to instruments should also be used for such a mapping exercise. Correct me if I commit a mistake.
Thank you. If I understood the question correctly, I think you're overestimating what we were able to do so far. So this one is actually a very basic exercise going through every country and jurisdiction's criminal code and criminal procedure code. So there is a lot of explanation about that and methodology, but it's all obviously open source. In some cases, we had access to official translations. In some cases, we had to do our own translations, but that was relatively straightforward. And then working with reports of other organizations when we wanted to provide references to cases. But that's kind of, part of the next stage is actually looking in practical terms, not in legal terms, but in practical terms, what worked and what didn't work and how it worked in a particular jurisdiction. And the second phase was for key jurisdictions. We could not do it for all 216, but for about, I believe, one third of the jurisdictions. I need to check the exact number. We basically went to lawyers who are experts on those countries and checked with them that our reading of the criminal code of their country is correct. And in some cases, it turned out it wasn't, or in some cases, we just, the words seemed simple and in a language that at least one of us could understand, but the actual meaning of the words was not obvious, especially because we're talking about the majority of countries that have never used these laws or don't even know that they have these laws. That was one of the feedback that we received from one of the Western partners who helped write the criminal codes of some of their partners in the so-called Global South. And they said, oh, now we are worried because we put it all in their criminal codes, but we don't think they actually know that it's there. And we don't want them to change the law because that would mean additional obligations for them. But hopefully this unintended consequence will not happen. So I hope I answered your question. So it was actually not, it was just a lot of work, but it wasn't very complex, digital forensics as we do for our actual investigations. That was just a lot of time and effort on processing all of this. And while I have the floor, if you permit me, I just put a link in the chat on a very important event that is happening in parallel with our conversation, but that is very relevant to what we're discussing. And that's the conference, diplomatic conference happening in Slovenia. Some of you may be aware, but for those who may not, and I do think that there are some ways of following it online, at least next week. And this is, it's a discussion of a major international cooperation treaty on atrocity crimes. It has very boring bureaucratic name, MLA Draft Convention on Mutual Legal Assistance, but it actually has very, very important practical implications for some of the things that were discussed here today. So I just put this link to the PDF where you have all the information, the draft law. Several NGOs actually intervened to make sure that victim protection provisions are emphasized in this law and so on and so forth. So it's there in case you want to check it out.
Thank you very much. We have to finish already our panel. I don't see any intervention or questions. Thank you all panelists for very rich presentations concerning your topics. And also thank you for people who discussed issues of the panel. I would like to congratulate already organizers of this conference and to say that I would like to say that it was an honor for me to moderate the second session. So thank you very much, and I will of course be with you during the third panel and closing remarks. Thank you very much.